Hi, this is Carlos Batara in another session of Simplifying and Demystifying Immigration Law. Today's session is going to cover the last chance defense, cancellation removal for non-lawful permanent residents. This is a tough place to be if you happen to have to use cancellation removal. What it means is that you're facing removal from the country. You're facing deportation, and you have nothing else you can rely on. It's the last chance defense. One of the first things that happens here is that you're placed in immigration court proceedings. Oftentimes someone's picked up, maybe they're driving down the road, they have a light in the back of the car, it doesn't work. At first it looks just like a minor violation of the traffic code. The officer checks your ID, you don't have an ID, so you get picked. They refer you to immigration. Immigration finds out that you're an undocumented immigrant or that you came here legally. And let's be clear about that, because 50% of those who are considered undocumented immigrants did arrive here legally. And so they decide to deport you. Well, you may be entitled to a hearing, and we're going to discuss when you're entitled to a hearing, and we're going to discuss what it takes to win that hearing. So, unfortunately, you're now taken over to immigration custody. From there, you will get an immigration court hearing with an immigration judge. So you're placed in deportation proceedings. There's nothing else available to you. So your immigration lawyer now says that, look, we have to try cancellation removal. It's a high-risk defense, very hard to win. Certainly, it's not something you want to do on your own. Very few cases are successful, but the consequences are great. If you lose, of course, you're going to be deported. But if you win, you're in line to get a green card and become a permanent resident. What do you need to win? Well, first thing is you have to have been physically present continuously for 10 years in the United States. If something broke that seriously, like prior voluntary departure, or that you were deported before, you're not going to be able to try to use this defense for your benefit. Secondly, and this is where a lot of people get tripped, is a good moral character requirement. Do you have certain convictions? Are there certain things you've done that is a blemish on your character? If there is, then you may not pass the good moral character test. But by and large, most individuals I've met meet these two requirements quite easily. The third requirement, this is where the rubber meets the road. This is where you separate cases. It's proving if someone has, if you can meet the requirement of exceptional and extremely unusual hardship, not to you, but either to your spouse, your parent, or your child, that's a U.S. citizen or lawful permanent resident. Let me say that again. They must be a United States citizen or a lawful permanent resident. And they must be a spouse, a parent, or a child, which means a child under the age of 21. How do you prove that? This is where it becomes very complicated. The judge will look at things like, what's your age? How did you enter? How long have you been here? The judge will look at the age of your children. Are your children citizens? What is their ability to speak the foreign language? Have they ever been to your home country? Will they be able to go back there and continue their education? Will they go to that home country and get teased because they're American citizens? What is your health? What's the health of your children? What's the health of your spouse? Do you need a special medical care provided here in the United States? Does your home country provide similar services? What about the ability to obtain employment? Does your home country have the kind of jobs where you can continue to support your family? What about how long your family members, other family members have been in the United States? Do you have family members in your home country? Very important questions. What is the educational system like in your home country? Those are factors that become very important. And essentially, when the judge looks at hardship, you're going to have to make a decision. You're going to have to make a decision at the beginning of the case which road you're going to take. Are you going to say to the judge, if I get deported, I will take my children, my wife, my parents with me back to my home country? Or are you going to tell the judge that they're going to stay here and you're going to go alone? Very, very important questions. And I don't know any client that answers that comfortably. It's sort of like an attorney who does a will. Who goes to an attorney and wants to talk about the day they die and how they're gonna give things to their children? It's the same thing here. No immigrant I've ever met wants to come to my office and tell me what they're going to do on the day they're deported. But unless you're serious and you can answer that question, it's going to be very hard to win your case in court. Other things that they'll look for in court is what's the psychological impact. For instance, if your wife is already having these nightmares and her health is deteriorating, if you can get proven medical support from psychologists, psychiatrists, then you can use that in court to your benefit. What are the conditions in your home country? Is your country in political chaos? Is it in economic chaos? Has there been a natural disaster lately? And then what about your contributions or your ties and the contributions and the ties of the children here? For instance, you have a child that's an A student in the 12th grade, about to go to college, and you are their only way of getting to college. You not only encourage them because you're educating in your home country, but you also contribute financially. Is that child still going to be able to go forward? Important question. Is there any way for you to come back someday as a green card holder? Another question. If your child's 9 years old, that means you get deported tomorrow, you're going to have to wait 12 years. Very important question for the judge. But this is where most cases bog down. This is in most cancellation removal cases where you're going to win or lose. This is where I say you separate the good attorneys from the bad attorneys. If they're going to put up a fight on hardship, they have to know hardship law inside and out. This is where most cases will be determined. Easily, in my experience, 90% of the cases in deportation proceedings in immigration court are decided on this requirement. If you can meet this strongly, then you will survive. Unfortunately, the law right now is not on the side of immigrants. It's a very strict standard. I believe personally they've misinterpreted the standard. I haven't been able to prove that in court yet, but I'm still fighting that battle. But in the meantime, we have to live by the way the courts have interpreted it, and we have to follow the rules to save you from getting deported. In any event, I hope that I've been able to explain this last chance defense. And remember, if you get stopped for even something as minor as a broken tail light, you could get put in deportation proceedings. Don't sign your rights away. Too many people come to my office because an uncle, an aunt, a husband, a wife has just decided not to sit in jail. They didn't know that they could possibly have a last chance. And they might have had a wonderful case where they could have put up a great fight. But instead, they gave it away and now they're separated for life. We don't want that to happen to you. We want to win your case. Fight back. Think cancellation removal.